won't try to enumerate all of those here, but I think the court has really sort of taken a step off of the, into deep constitutional water with this new test that makes it difficult to assess the constitutionality of important questions. I'll take one example. Let's say that the constitutionality of requiring people to put serial numbers on firearms comes before the court. Does the fact that the government used to do that for inventory purposes during George Washington's time give them the authority to force both private individuals and gun manufacturers to serialize firearms that they produce? Is that a relevantly analogous, sort of historical practice, or is it not a relevant analogous? And that, by this I mean, again, sort of what Drew mentioned is George Washington stamping numbers on firearms. That's to keep track of their own firearms, not to make sure they can keep track of yours. So I think that that's going to be a real challenge for the court, because it's not at all clear why historical practice answers modern day constitutional questions. Maybe it's of some help in contextualizing them in some cases, but I'm deeply skeptical that historical practice yields or can yield a satisfying answer to all modern constitutional questions. But I'm afraid that that's the kind of box that the Supreme Court has painted itself into in the wake of the Bruen and Rahimi cases.
Drew, your thoughts on how the post-Rahimi debate might affect the future of ghost gun regulations and the landscape moving forward.
So this is a point where we completely agree. I think that the history of our legal history and traditions are always interesting and relevant and worth talking about, but the historical record is simply too incomplete, and it's too much in the eye of the beholder how much weight we give to one scrap of historical evidence versus another. If we have a letter from Thomas Jefferson that suggests he thought the Constitution meant one thing and James Madison says the other, and we know they disagreed, like, who do we side with? And the fact is, judges, the lower court judges, are trained as lawyers, not historians. We all like most of us like history and have watched the History Channel, but we're not professional. We can't do rigorous history. We do kind of amateur history, and so I think that the Bruen test, as Jake Charles at Pepperdine has called it, is kind of a Rorschach test where people see what they want as they try to apply it. The one thing that Bruen does is, because it's so confusing, it guarantees that the cases are going to keep coming to the Supreme Court, and they're going to get to decide things on a case-by-case basis. And I think the contrast between how they ruled in Bruen versus Rahimi, where in Rahimi they upheld a federal statute, suggests that we have some people on the court, including conservatives, who are going to carve out some of our gun laws as okay. And I know that there are a lot of people in America who are what I would call Second Amendment absolutists. They read the Second Amendment as saying Congress can't make any gun laws about guns at all, anything that relates to gun sales or use or ownership. But there is no one on the Supreme Court that seems to hold that view right now, a truly absolutist view about the Second Amendment. So it's going to come down to individual votes. What do I predict? Based on what they've signaled, I think that they will uphold the felon in possession law and some of the other 922G categories, undocumented immigrants, and so forth, where they have had opportunities to overturn those laws even since Bruen and have passed on it. And so I think that we're going to end up 5 years from now where they have basically sort of circled a bunch of our existing laws and they're going to say these are here to stay for now. And then others, like maybe assault weapon bans, I don't know which way they're going to go on that. Or some of the innovative rules that are coming out of California, like microstamping, I really don't know how they're going to go on that. Those are more likely to be challenged. I think the federal laws in 18 USC 922G that we've had now for a whole generation, most of those are likely to stay with this court, with the current makeup of the court. That's my prediction.
Clark, you're a vigorous and eloquent defender of the Second Amendment, although you're a critic of the Bruin test. Give us a sense of how you think the court will approach issues ranging from the felon possession ban to assault weapons over the next 5 years.
Yeah, I think that Drew could be right. I think it'll depend maybe on the extent to which the justices are prepared to sort of become granular in their analysis, right? So it's one thing to say that somebody who commits an armed robbery of a bank loses their right to own a gun for the rest of their life. But it's another thing to say that somebody who committed some kind of state food stamp fraud 20 years ago, which is an actual case that's pending in the system, should never be able to own a gun again. And of course, at the time of the founding, there weren't very many felonies, and they were all very serious. And if you committed a felony in, the late 18th century, you were probably a pretty bad person, or at least you'd engaged in a significantly antisocial act. Now the whole concept of a felony has been utterly cheapened. There's some people who argue, I think credibly, that most adults by some point in your life, you've probably committed a felony of some kind, whether you know it or not. So I think it'll really come down to, are the justices willing to look at this on a case-by-case basis? Similarly, there's another provision of federal law that makes it illegal for an unlawful user of a controlled substance to possess a firearm. Well, guess what? That includes marijuana, and more people in America now report being regular users of marijuana than alcohol. Does that mean that every single one of them gives up their Second Amendment rights while during the time when they're using one intoxicant that frankly is probably safer for people to be using if they own a gun, because they're going to be looking for a bag of Doritos, not a bank to rob. But anyway, the court, I think, is not really clarified for us, or the justices who tend to be more sympathetic to the Second Amendment have not made clear whether they're prepared to get down to that level of granularity to try to decide kind of what's sort of constitutionally defensible as to that particular litigant, whether it's a defendant or a plaintiff. And if they rule in broad brushstrokes, and I think Drew's right, most of federal gun law will be upheld. But if they're prepared to get down into the nitty gritty and say, is this law constitutional as applied to this particular person who came back from Iraq with post-traumatic stress disorder and smokes weed once in a while to help get himself to sleep, that's a much more sympathetic case, obviously, and I think we could get different results, but I just don't know which way the court will go.
In addition to the constitutional debate, there's an important debate about administrative law and how deferential the court should be to gun regulations from administrative agencies. In the Garland and Cargill case last term involving bump stocks, the court struck down the ATF's rule 6-3. Drew, give us a sense of what the significance of the case was for how the court will view these questions of administrative deference and guns in the future.
So, as you know, that this is all kind of happening. There's a parallel track of cases going on right now with something called Chevron, the Chevron doctrine and Chevron deference. The court getting rid of that this past term. And I have to tell you, this is an area of law I follow. And again, since the Loper Bright case last summer, the lower court cases are a little bit all over the place. It doesn't mean that the agency always loses. It does mean that the agency has to come into court and convince the court that their interpretation of the statute is the best one. And that on controversial questions like gun rights are very partisan. That's an uphill battle. There's plenty of other regulatory questions that are less divisive. And in some ways, the case this week, Vanderstock, is an example where it seemed like a lot of the justices, even though they ruled against ATF about bump stocks, think that the serial number rule, the ghost gun ban, is okay. It makes things a little. I agree that it makes things somewhat unpredictable, and it's also going to make it a little bit higher stakes. Our congressional elections in the coming years, because it shifts some of the weight back to Congress to pass more specific statutes, or to make it clearer in a statute. We think that here's a range of options that are acceptable for agencies to adopt and as regulations. I do want to add, Congress has started only recently to routinely invoke the Congressional Review Act, which is a sort of a legislative veto of agency decisions. So we will have to see who wins the White House and whether one party is able to control both houses of Congress. Right now, when you have different parties controlling each house of Congress, very few statutory amendments get enacted and get passed. And I sympathize with the position of the Cato Institute that I think that the founding fathers set up a system that would have a lot of friction and gridlock, so that legal changes would have to happen incrementally. And I think that is what we're going to see going forward with gun regulations. And from the administrative law standpoint, is that we're going to see more and more incremental change. I do want to add, for probably the last 5 years, ATF has not been asking for Chevron deference, either because they expected it to be overturned, or because the new regulations were actually consistent with what they were already doing in practice. That's what they are claiming, for example, in both the ghost gun case and the bump stock case, is that, and right now if I can talk about the gun violence problem in our country, an even bigger problem than ghost guns or bump stocks is Glock switches, or the auto sear devices that convert a Glock or some other firearms into fully automatics. And they're now widely available and very cheap. And ATF is already prosecuting hundreds of people a year over Glock switches, over making them or selling them or possessing them. And so part of what's happening is the regulations, I think, are often catching up to enforcement practice.
Clark, I think you're a fan of the overturning of Chevron. What difference will it make to the future of gun regulations, and how significant is the bump stock case moving forward?
Yeah, I mean, look, I think that it's entirely reasonable for somebody to say that if my possession of a hunk of metal or polymer exposes me to a 15-year prison sentence, which is the significance of this new rule, you ought to know what kind of metal, like what exactly is it that you should not be possessing. And the ATF has this 8-factor test, and it involves a bunch of considerations that I think you could get a lot of disagreement. And so the ATF, I think, is counting on the idea that people will just not even take a chance. When in doubt, don't possess anything that could be characterized as a receiver. And I don't really think that's the country most of us want to live in. I mean, just flip the switch, right? And instead of firearms, imagine we're now in the area of immigration, or medication, maybe even a medication that's of particular interest to women who find themselves in a particular situation, right? Do we want people in those situations to be exposed to a 15-year prison sentence because they essentially made a rational and reasonable decision to do something that it turns out some federal bureaucrat says, nope, that was within the ambit of the statute as we understand it. And I think all of us want to know that it was Congress that decided this is going to be the policy, and we think that this is a serious enough act of misconduct to put you in prison for a long time, and not, again, some federal agency that can change its position with the change of administrations, which was what the elimination of the Chevron doctrine in part is hopefully going to avoid, where agencies change their position on the meaning of statutes as different presidents come in with different priorities. The last thing I want to say is that this point about the exposure of people to significant prison sentences for just possessing the wrong hunk of metal or polymer was raised at oral argument, and the Solicitor General kind of tried to wave it away by assuring the court that the ATF had no plans of going after people on borderline